to Advice conference. I've organized it on behalf of the Access to Advice Network in Liverpool, which is a product really of the Access to Justice project, which is a collaboration between the University of Liverpool, Liverpool City Council and Citizens Advice Liverpool. For the last 2 years, I've been working on the EU settlement scheme, and increasingly I have found that there is a huge interaction between different advice areas and intersectionality between problems with obtaining status under the EU settlement scheme, and at the same time problems with accessing universal credit or being able to prove your rights to an employer or a landlord, and therefore struggling to access housing and so on. I'm now the partnership coordinator for the Access to Advice Network, and as such, of course, we're all about working in partnerships and looking after clients in different advice areas and working in partnership between different organizations that work in different areas. So we want to get together and talk about how these different areas of advice and these different areas of people's lives interact with each other. We've got a really good program today. I've shared a PDF with the program in the chat. Please do say hello in the chat, ask questions. We're going to start off this first section really talking about the effects of Brexit and what's been going on in the last year, but also casting our minds back historically a little bit to the Windrush generation and looking at the parallels between what happened to people who were affected by the Windrush scandal and what's going on with the EU settlement scheme right now. We're recording the speakers, and then we will have a Q&A session, and during that we will switch off the recording so that people can then turn their cameras back on and hopefully unmute themselves, and we can have a lively discussion. We'll have a short break at 11. We will have more speakers between 11 and 12. Then we will have a lunch break, and after lunch we will have some breakout sessions. As we move through the day, obviously I'll give you more details. Now, I actually feel very honoured and very privileged to welcome a representative of the EU delegation in the UK. Daniel Fleischer-Ambros is joining us, and he will be the first to speak to tell us a little bit about the perspective of well, I suppose the change in status of the UK within the EU, or now outside the EU, and the change in status for citizens who came here exercising freedom of movement treaty rights, but obviously now have to have an immigration status. So Daniel, thank you very much for joining us. Köszönöm szépen, and jó napot kívánok. And please, over to you. Please unmute yourself, and welcome, and thank you for joining us.
Thank you very much for your welcoming and for this opportunity to be with you today. And basically, I just wanted to say a few words before we all get started with a more in-depth discussion, because obviously the UK's withdrawal from the European Union has brought fundamental changes to the lives of millions of citizens, whether they are British citizens and their family members residing in the EU member states, or EU citizens and their family members residing in the UK. These changes, I'm afraid, are now hard felt. Obviously, I'm going to focus a little bit more on implementation of the withdrawal agreement in the UK and EU and their family members in the UK. Just to say that overall, I think the EU settlement scheme, which is implementation of Part 2 of the withdrawal agreement on citizens' rights, has so far largely been successful. Of course, we started with a situation where nobody knew for real how many eligible citizens there might be residing in the UK. There were various estimates 2-3 years ago, and now it is clear that by the 30th of June there have been more than 6 million applications. We concluded from that there appears to be at least 5.5 million individuals who may have applied. Of course, the overall number includes double entries, reapplications, and so on and so forth. But this is a very large number, and I think it far exceeds any of anybody's expectations. So the reality is now starting to take shape that many more citizens are being affected by this than what the original estimates hoped for. And also to say that on the 30th of June, life hasn't stopped. Because we know that only in July there were additional almost 60,000 applications submitted. We also know from the Home Office that there is still a substantial uptake as we speak these weeks, some of whom are late applicants, some of whom are joining family members. So the drive to get everybody covered is not over yet. Maybe we will discuss more in depth who are those who are likely to still submit an application. Predominantly, we feel that those are senior citizens, children, and of course, those with more vulnerable or complex case backgrounds. Now, of course, as we need to keep an eye on the uptake and ensuring that everybody who is eligible applies and gets status, we will also need to focus in the coming months and years, I have to say, on those who have obtained status. First of all, to start with, that we have over 2.3 million citizens who have pre-settled status, who in due course will need to effectively reapply and get a settled status if they wish their rights to be protected in the longer run. So those are, again, 2.3 million people who will need to take action in the future. Each of them has an individual deadline for the time being. So from an outreach and comms point of view, it's not as easy as before. There's no universal deadline. Each of them have to be aware of their own deadlines. And then, of course, the other big area worth focusing on is how those who have status, whether pre-settled or settled, or even those who have submitted an application and are waiting for a decision, can exercise their rights. We welcome the British government's decision to protect late applicants, which we always found to be a very important aspect of the withdrawal agreement. So today, even those who apply late have their rights protected as per the withdrawal agreement. They're able to begin a new employment or rental contract. They should have access to healthcare and social services. So this is a very good development that we welcome. But we also have to keep an eye on how successfully can citizens access their digital-only status and share their profiles with those who need to conduct immigration checks. And also, we have to look at how successfully those who are obliged by law to conduct these immigration checks can view citizen statuses. Now, over the past weeks or so, together with a number of assistance organizations, many of whom I know are following this conference, and also together with the embassies of EU member states, we started to detect some issues which I'm afraid some of us have been suspecting to come in due course, which relates to citizens' challenges accessing their own status, updating their status, and also the challenges related to those who need to check immigration checks. For instance, just to give you a few examples, we've heard of employers who wanted to obtain additional documents beyond just a digital profile, which of course is not allowed. We still have issues around how everybody responds to certificates of application. There seems to be a bit of confusion on the ground as to what rights are covered if you have a certificate to show. Of course, these have recently changed because the UK has changed its position on late applications. We have also worryingly lately received some reports that university students have issues. Some universities don't tend to accept certificates of application, or some types of pre-settled statuses to be eligible for home fees. So these are the types of issues that we will need to continue to monitor. And this is why I think this discussion on what the advice sector can offer, it's really important. I think we will have to welcome the news from the Home Office that they are planning to extend the grant funding for assistance organizations. I think this is very, very good news. I also wanted to add that the EU delegation also has a very modest service, public-facing service of advice surgeries, which are being delivered through Seraphus solicitors, which we will continue to offer for citizens who have complex cases or complex backgrounds or are vulnerable, whether it's about applying late or understanding your rights. But I think we will have to agree that all of these mechanisms appear to be temporary, whereas there continues to be a much longer need to assist citizens. And this is why I think it would be good to have a discussion on what are the prospects of any long-term solutions. I know that this is a hotly debated topic in the sector itself, also beyond the scope of the EU settlement scheme. But I just have to say that we now have millions of citizens potentially joining the circle of people who might need some assistance sometime in the future. And I would like to think that all of the mechanisms put in place today will continue. But I think it's realistic to say that only a more structural and permanent solution would ease our minds in the longer run. So I'm very much interested to hear the views of others with this regard. And I think there's unfortunately lots of work ahead of us when it comes to not just EU citizens, but also always reminding that their family members who could be non-EU citizens. So many people are covered. This is all I wanted to say as an introduction. I'm sure we're going to revisit some of these more in depth. And as I said, I'm very curious to hear the views of others and trust that this today will be a very constructive discussion with some operational conclusions that we might be able to follow up on. Thank you.
Thank you so much, Daniel. Yeah, you have absolutely stolen the words from my heart there, because we've always, from the outset of having grant funding, we've always had a looming end to funding. So as well as a looming deadline, we had an end to funding in sight initially in March 2020. That was extended to June 2020. Then came the lockdown. Then that was extended. Then we expanded our EUSS project and actually got more grant funding. And we now actually have added a funding stream as well. And as much as we're very grateful that the grant funding was extended to the end of September, here we are. It is September. It's the end of this month. And the need is still really, really great. And what we really need, like you say, is a permanent funding for it. We have good systems in place, and we have wonderful advisors that we've trained over the last 2 years that now have really good experience. We will hear from some of them later on today, but we need continued commitment to looking after people and offering them help and advice, because there are digital barriers as well as a huge amount of lack of understanding. So I hosted a series of information sessions for employers and the reason we put these on was because we saw a need for them. We don't want to be adversarial with employers. They're just trying to do what they are supposed to do, but they were getting it wrong, and ultimately people were getting discriminated. So we will be looking at those issues as well. And I would like to now hand over to Nigel. Nigel Guy is from Windrush Generations, and we can learn a lot from the Windrush scandal. Thank you for joining us today, Nigel. It's lovely to see you again. And I think it's the reason I put you sort of right at the start of the conference is because I really wanted to set the tone by saying, well, this is what can happen, and actually possibly on a grander scale. So Nigel, thanks for joining us, and please will you tell us about the lessons we can learn from the Windrush scandal. Over to you. Please remember to unmute. Thank you.
Morning, can everyone hear me? Good morning, Cozy. Thank you very much for enabling me to be on this conference, and also listening to the opening speaker, Daniel. And I've been requested to kind of give some updates or similarities on how the Windrush scandal and those affected by the hostile environment may be similar to how people from the European Union who are seeking citizenship and the right to remain. Now, Daniel had just spoken, and I could have used all these words and just transferred one word. Instead of EU citizens, it could have been the Windrush generation, because there are very, very much similarities in terms of the effects that people have. And I need to say what the effects people have in terms of the Windrush scandal and those from the Commonwealth nations who've been affected, who believed, who came to the UK with British passports, you know, since 1948. People were coming before 1948, but the Windrush empireship has been acknowledged as a significant moment of people arriving in the UK from the Caribbean. And the Windrush scandal, in terms of people affected, have affected people from many countries, not just the Caribbean countries, the people from Australia, people from the continent of Africa, people from the Asian, South Asian communities, such as the Pakistanis, the Indians, the Bangladeshis, and people even from South America as well. So in a sense, the list is extensive. You may hear a lot about people from the Caribbean who are affected, and predominantly there are many people out of that proportion who are being affected by the Windrush scandal. I'm Nigel Guy, and I'm a director of voluntary organisations as Windrush Generations UK, and also the Windrush National Organisation. And it's come about through the struggles that people are having, and I know the similarities. When I mention these words, you need to connect that through the EU citizens as well, that they're being affected by these struggles. And it's by legislation and new acts that the government, successive governments have put in. So picture this in terms of similarities and the learnings. You arrive, your parents arrive, or you arrive to the country of the UK with that acknowledgement that you've been accepted as a citizen. You have the right to remain, the right to work in the UK and establish, and therefore you're establishing stability. You're establishing, you're settled, and lo and behold, after so many years, you're told that you're not wanted, you don't have the right to remain. That's how the Windrush generations have been affected by the hostile environment and government legislation that has changed. The similarities also in the sense of what the EU citizens are facing in terms of what Windrush generations have faced and still are facing is the ability to actually correspond with the Home Office and the governments in terms of their requirements of getting people to apply for new applications to remain in the UK. In the 1980s, the government had changed the legislation to request people to actually reapply or to apply, become citizens of the UK. So therefore, they had to pay a lot of money to actually go through a process, and some people just did not have the money, nor felt that it was necessary for them to actually what's the word now, to acknowledge, the word is not acknowledge, but for them to actually say that they are British citizens when they were actually given consent to come into the country with a British passport, and therefore even their descendants should have the right to remain in the country, but yet there is still difficulties with their descendants proving that they are British citizens, even with their parents having their British passport or right to remain, there are still issues for their descendants to actually receive citizenship. So in a sense that even though you may feel that the initial first generations who arrived in the UK may also have British citizens, and some may not have, but those who have, their descendants may not qualify to be British citizens and still need to go through that process. The difficulties that we're facing in terms of the Windrush scandal is that people are not coming forward. Why? Because they do not trust the Home Office, and the Home Office are trying their very best to turn a new leaf, to become a new machine, a new animal of coziness, when in reality they're a very stern organisation in terms of what they have to do. I'm not knocking that they have a responsibility to ensure that the borders are controlled, but when they're actually putting pain and suffering on people who ordinarily believe that they had stability within the UK and now being told that they don't have a right to remain, has become a very big issue. And yes, the government have realised in 2018, and when the Windrush scandal broke, that the policies and procedures that they put forward were not fair, and obviously that made the UK look very shameful around the world of how they were treating people who came to the UK to establish and contributed many things to the UK and being part of British society, the way of life in all facets of UK society. These are the difficulties that people are facing, and the difficulties people are facing is access to actually completing forms, very draconian, very difficult forms. Would need lawyers to actually help them really fill out compensation forms as well. But in terms of UK status, you know, the government has realised that they need to provide assistance to people, and it's very difficult even for people to get that assistance as well. And I know there's agencies around, and people are not coming forward nor needing to find papers that would enable them to come forward and have their application approved by the Home Office. And the Home Office not providing full support for the Windrush generations in terms of getting their status, and those who rightly should have their status. So there's similarities there in terms of funding, but also when people have received their status, they obviously have the opportunity to apply for compensation for the pains that they have. Now, I don't think there's a compensation scheme for the EU citizens, but they will be affected by the approach that the governments have taken. And I say successive governments because the scandal for the Windrush scandal was not just the Conservative Party, it was the Labour Party and many successive ministers as well, in terms of being very hostile in their approach to people who we believe, who we know are there to actually make a way in the world. So what the similarities of the EU citizens seeking citizenships and the right to remain are very similar to the Windrush generations. And I want to say is that the government need to actually provide more assistance. They've extended the in terms of EU instead of citizenship or right to remain for the UK, that's still open. There's no deadlines for the Windrush generations, but also there's a fear of people being deported whilst not having the correct papers to move forward. So people are still living in fear. And one thing that people don't have, which they thought they had, was stability. And that provides a hesitancy to come forward to the government quangos such as the Home Office to feel that they're ready to embrace people. And I'm hoping that the EU citizens will have the opportunity to actually engage more fairly and have the support networks that are there, such as the citizen advice and all the other agencies to move forward. And that work is still being applied for the Windrush generations in terms of increasing the outlets and the advocacy and the knowledge base to help people move forward in terms of obtaining their citizenship. And during that process, and I know that many people through the EU citizenship schemes are feeling that instability and not knowing where to turn. So, you know, I'll be listening in today, and I'd just like to say that Daniel spoke earlier that if I'd used his speech and just said Windrush generation instead of EU citizens, then that's the learning. So on a final note is just to keep pushing and keep lobbying and you know, because you have to keep challenging the ministers, the Home Office, and then all those commissioners to say that more needs to be done. And I'm glad that I've heard that there may be an extension of time in terms of funding, but also in terms of allowing people, enabling people to have that time to prepare and get the right papers as well. I just hope the process becomes much easier. And like the Home Office, they're trying to make it much easier for the Windrush generation, but their idea of easier is not really in terms of the public setting. Easy. So it's a very difficult process, and there's a lot of learning, not just from the people who are actually trying to assist those who are affected by this hostile environment and the changes in the citizenship law, the borders and immigration, but also for the Home Office to be more patient with people in moving forward. So I thank you very much for giving me the opportunity. You know, if you want to know more about what's happening with the Windrush generations, we have monthly meetings with the Windrush National Organisation, and that's on www.windrushnationalorganisation.com. So thank you very much, Cozy, for giving us this opportunity for me to give some similarities of the position that people are facing with these immigration problems. Thank you.
Thank you so much, Nigel. Nigel, thank you for joining us, and thank you for highlighting the similarities. It's always a pleasure to invite you and to listen to you. And this is the thing, we do need to keep reminding people of the similarities, and also the Windrush scheme obviously does not only apply to Commonwealth citizens. She says, carrying her own Windrush card, because I have been in this country so long that I was able to make a Windrush application, and I have assisted clients with applications for Windrush compensation. It's not a great process. It's a very difficult process. You're having to rake into people's past, into very difficult times in their lives when they were denied access to housing, denied access to benefits. So what happens when you're denied access to benefits and housing? You end up sleeping rough, you end up on the homeless, either sofa surfing or on the streets. And you don't necessarily want to relive that. It felt, you know, sometimes in these conversations, it felt like almost like I'm re-traumatizing my clients. Yeah. And while people are having to go through these processes and their statuses are not secured, and as you say, they're denied access to rights, they are in limbo, which takes me to our next speaker. And that's Elena Remigi from the Limbo project, who have published 2 books of testimonies. I'm on page 144 of the first book, and in Limbo is what I did before I got a full-time job. And I'm so pleased to welcome you to this conference, Elena, because you will be able to tell us some of the testimonies. Daniel, you said earlier that you know, the withdrawal agreement protects people's rights, and this is the theory. This is what should be happening. These are the underpinning laws, but now we're looking at the practice of what is actually happening on the ground, and Daniel already alluded to it, that it's not also straightforward and also easy. So Elena, you will be telling us about some of the testimonies, and I would also like to say, Nigel and Daniel, if you want to put any links or contact details, or any of the other speakers and any of the other participants, feel free to put links and contact details in the chat, and you know, pick up conversations outside of this conference. It really should be an opportunity to make new connections and do some networking. So with that, thank you so much for joining us, Elena. Mille grazie. Elena is actually joining us from just about here in Italy. So thank you for sharing some sunshine with us. And over to you.
So good morning, everyone, and thank you, Cozy and the Access to Advice Network, for inviting me. My name is Elena Remigi. I'm the founder and director of the In Limbo project, which has collected testimonies from EU citizens and British ones since 2017 to highlight the human cost of Brexit. Today, I was asked to give you a glimpse of what life has become for many EU citizens after the end of the so-called grace period of the 30th of June. I shall be focusing on testimonies and on the emotional impact all these changes have had on people's lives, on people's daily lives. But before doing so, I would like to go back for a minute to what these 5 years have meant for many of us. After reading story after story about the concerns EU citizens and their families have experienced since the referendum result, I can assure you that the emotional impact on countless lives, and we've dealt with a few thousand, has been huge. For many EU citizens, finding themselves in limbo, having their lives put on hold, has been extremely difficult. I remember with our team advising many citizens to seek help from organizations which could provide psychological support when it was clear that the person needed more than friendship or practical help with documents. But has the advent of settled status come as a panacea to solve everything? Are we all fine? Is it all sorted all over? Well, we know this is far from the truth, and that the real difficulties and implications of settled status are beginning to emerge only now. So I shall give you some example, as I was saying, of how life has changed for those who have pre or settled status, and then move to those who don't. As you know, one of the main issues people complain about in our groups is the lack of physical proof of settled status, from which a myriad of issues stem. To give you just a few examples, I'll start with Emily, who writes from Italy. My son applied for a position for a well-known company, went to their induction day, provided the share code to prove his right to work, and guess what? It didn't work. So they sent him home. I'm so angry for all those finding themselves in similar situations. Then we have Joanna from Poland, who had no trouble at first getting settled status, but then one day she decided to check online. And as you can see from slide 1, this is what appeared and is still appearing. She writes, I decided to test whether I could generate a code as my secondment is coming to an end, and I wanted to start searching for jobs. To my horror, multiple attempts to generate the code failed. I have tried to use different browsers, different times of day, week, with no luck. Also, the photo I have submitted with my application now, it's not available. I'm very anxious. I'm going abroad soon and I need to get this sorted. Then we have Natty, a Spanish lady who's lived in the UK for 29 years, and she was moving into a newly rented accommodation, and she writes, after proving all the documents required to satisfy the new right to rent procedure, they have emailed me the day before moving, meaning the agency, to say that unless I show them the correct codes to prove my status, they won't hand the keys tomorrow. I have followed the link to the Home Office. My data doesn't work and the system doesn't recognize me at all, so I can't produce the code, as you can see on slide 2. I have begged the agency to allow me to move in, as I have hired a van and I can't stay any longer, as someone else is moving in at the weekend, but they say it is illegal. I tried the Home Office number, which is always engaged or disconnects you because there is a long queue. I'm so afraid I might end up homeless. Then Silvana from Italy. She writes, I have lived in London for more than 20 years. My 2 children were born here. I applied for settled status for the 3 of us, and whilst I didn't have any problems with my application and my daughters, my younger son didn't receive anything by the 30th of June. I'm very concerned and anxious because having done a paper application, we have no certificate, no proof, no way of proving that my son is legally in the UK. Finally, Honorata from Poland writes, I'm an NHS worker who was granted settled status 2 years ago. I updated my passport in December last year and I received confirmation that my details were updated. Since then, when I tried to view my status, I constantly see the statement, we cannot find your current status. You can see that on the next slide, slide 3. I'm planning to purchase a property and I'm traveling to the EU in September. I'm really concerned. So after endless calls to the centres, most of these issues were eventually solved. But don't tell me that this new normal is acceptable. Emily's son missed a week of work. Like in Silvana's son case, we know of many adults who haven't received their certificate of application, and they risk missing job opportunities and even risk losing their job securities because some employers have carried out retrospective checks, though in theory they shouldn't have. Others, like Natty, are having trouble renting. We've seen cases of discrimination. For instance, we had an African citizen with pre-settled status because he was married to an EU citizen and then separated, who tried to rent a place. But the landlord struggled to understand why he was entitled to settled status and in the end preferred to rent the house to someone else. Then, of course, we know there's a backlog of more than 500,000 people waiting for their status. So you can imagine the anxiety people face when their lives depend on a code working, on being found on the system, on finding a landlord or an employer who understand how settled status work or pre-settled status. These are not isolated cases. It's a new normal, and the anxiety amongst people is palpable. I have never received more emails with urgent as the object as now. And speaking of worry, we've had several people telling us they decided not to go abroad to see their loved ones after the pandemic for fear of crossing the border and being detained if anything went wrong. Well, who can blame them, I thought, after they saw what happened in May when people were held in detention centres when they failed to provide the right documents. To contribute to this climate of fear and general mistrust in the Home Office, we've also had unhelpful episodes such as when 70,000 letters were sent to citizens during the month of August, when people are also more likely to be on holiday, which stated that anyone who was in receipt of benefits or of a pension had to apply for settled status as soon as possible, otherwise they would have lost them. If the letter was sent by mistake, the only way one could rectify was to contact a number within 28 days. Pity that it wasn't easy to find the line free and that nobody was informed of this mail shot. So panic ensued, particularly with those with settled status or British citizenship. But what about those who haven't applied for settled status or late applicants? Who are they? Well, some are too old or vulnerable. I'm thinking of people like a lady who came to our group whose father was in a care home with dementia. She suffered from severe depression and turned to us for help. But at one point she was so unwell that she vanished, and we fear she never applied. Then there are parents who didn't apply for their children because they didn't realize they had to. We found another one just a couple of days ago. And, speaking of children, we know that some are have been refused settled status because the parents couldn't find enough proof of residence, particularly if they moved during the pandemic. And speaking of the pandemic, others missed out because many centres for face-to-face meetings, consulates, embassies to renew their IDs were closed. So all these people and more, I'm thinking, for instance, of victims of domestic abuse or modern slavery, etc., or minorities, are at huge risk of falling prey to the hostile environment. We are talking of citizens who were lawfully here until the rules changed. So how do EU citizens feel about this? This Wordle, as you can see on slide 4, where we collected more than 500 answers, shows there are more prevalent feelings. People feel betrayed because of a broken promise. We've gone from nothing will change to apply, or otherwise you could lose your rights. They feel unsettled because they lost their sense of home and belonging, to the point that many of them are thinking of leaving or have a plan B. Some feel unwelcome, angry, worried because of the difficulties they're facing in proving their right to stay. And many, as you can see on the last slide, slide 5, are concerned for the elderly, for the vulnerable ones, for the less tech savvy. They fear a new Windrush happening. So, as in Limbo, we will continue to ensure that people don't fall through the net. We will continue to create a solidarity network offering support and guidance, And we will try to keep the attention high on these issues to avoid the silence which surrounded the Windrush generation and made it harder for them to fight back. Thank you for listening, and back to you, Cozy.
Anyway, with that, thank you so much, Elena. And I mean, obviously, you mentioned the letters that went out. We had so many calls. Our EUSS admin, who actually is the wonderful Christina, who did so much work in the background preparing this conference, and she created the Eventbrite and everything. She's been working with me since last October and been absolutely wonderful. She was inundated with calls of clients who were, who had received this letter and didn't understand what they had to do. They were like, but I have settled status. I've had it for 2 years. Why are they writing to me now? Or they are British citizens. I'm a British citizen. I can't apply. What do you want from me? And we had one client who called us really in a panic saying, I've called this number, but it doesn't actually say that this is from the government. Who is this from? I've just given them my passport number, my national insurance number, my name, my date of birth, all the information that you could use in identity fraud, anything you need to clone an identity. And he was worried that it was a scam. And it looks like a scam, frankly, because there's no official branding. When you call up the number, if you call after 4:30, by the way, it's only open 9:30 till 4:30. How's that supposed to work for the working population? You get an announcement, but it doesn't say you've reached the Home Office or you've reached a government department. It just says this office is now closed. So there are a lot of problems, and it's not just the digital exclusion. The reality is simply that the system's not working, and it's putting people at jeopardy. So with that, I'm going to move on to Chris Desira from Seraphus, who have spent the last 2 years traveling up and down the country and giving information sessions, initially in person. Chris's little overnight bag saw many train stations, and we met at many meetings, and then of course moved online and did many Facebook Live events to try and inform EU citizens as much as possible about the EU settlement scheme, the fact that they have to apply, when they have to apply, by who needs to do what. And actually, personally, I'm extremely grateful for the resource materials that were on the Seraphus and EU Rights websites, because they were updated in real time. We have to realize and remember that back in 2019, we were still in the Article 50 period. Article 50 had not ended; it had been extended, and it was extended several times. So the teaching materials and the information materials were updated in real time, and they were showing the parallel pathways. If we have a hard Brexit, this will happen. If we have a withdrawal agreement, this will happen, and so on. So they were extremely useful in a very, very confusing time. With that, I would like to hand over to Chris Desira for the next 10 minutes or so before we have the Q&A. So thank you for joining us, Chris.
Thank you, Cozy, and thank you for those warm words. So, as Cozy said, my name's Christopher Desira. I'm a solicitor at a law firm called Seraphus. I'm going to talk a little bit about some of the most pressing issues of the day. Just a bit of a warning, clause on my part. These words are my own. They're not the words of the EU delegation or any other clients that we work for. So these views are my views alone. There was a really important speech by Nigel early in about the parallels of requiring leave to remain, and also the papers please approach that is embedded now within the UK immigration system, and is now impacting not just EU citizens and those from the Windrush generation, but now British citizens who have to engage with anyone who needs an immigration status. And those parallels have been known for a long time, and having travelled across the entire United Kingdom and Northern Ireland for at least 2 years, speaking to different communities of different backgrounds, large and small, EU and non-EU alike. Those fears are evident everywhere, whatever their backgrounds are. And obtaining settled status is really not the end for this. There's going to be continual difficulties in accessing rights and entitlements, difficulties with some people going about their normal day-to-day process. And we've also heard about the feeling of insecurity in one's life, particularly as future mistakes can also lead to a risk of settled status being lost. If someone gets into future trouble with future criminal offending, a simple mistake may impact their immigration status. So this insecurity can be felt within the community, which is also a reason why huge numbers have moved to try and become British. Those numbers tell us that insecurity is still being felt, even though one gets settled status. And the testimony shared by Eleanor shows this. But let me talk about some of the pressing issues. I say this now, but also I do acknowledge as well that the scheme in its main objectives has been largely successful. The UK government has implemented an application process which has captured millions of people in a very short space of time. So some of their goals have been met, but there continues to be problems with this process. And I think there will be continual problems with this process while we still have this system in place that requires non-government entities to become, in essence, enforcement officers. So while we still have right to work checks, while we still have landlord checks, while we still have this papers please approach, there's going to always be continual problems. That's the consequence of having this type of approach. And in my opinion, an immigration status and holding the correct immigration status really should be a relationship between the individual and the state, and it should not pull into that relationship employers, landlords, the NHS, and everyone else who now is required to check these statuses. But let's talk about the pressing issues of the day before my time runs out. So I want to talk briefly about late applications and these temporary protections that the government announced on the 6th of August. In essence, the government has announced that those who apply late to the EU settlement scheme, that's after the 30th of June 2021, should see no loss in rights and entitlements. What rights and entitlements they had pre 30th of June should be reinstated post 30th of June once they make a late application to the scheme. Previously, before this announcement, late applicants will only be able to reinstate one right, which was free access to secondary healthcare. That would be reinstated on a late application being made. But now, post this announcement, and we've yet to see the policy papers behind it and the detail behind it, post this announcement, the Home Office have said, well, anyone who makes a late application can see their rights reinstated. This includes access to new employment, access to new tenancy agreements, and access to new benefits entitlements. Now, why did the Home Office make this announcement? Well, although the announcement is brief and it makes no reference of this at all, it's because they were required to do this under the withdrawal agreement. It appears that the UK government accepted that their approach with late applicants having restricted rights and entitlements was probably not withdrawal agreement compliance. So they've made this announcement to bring themselves within the withdrawal agreement, and so those who apply late can now start moving on with their lives. What does this mean? Well, we've seen some changes to some of the Home Office guidance. So, for example, the Home Office guidance on right to work checks have removed references to the application deadline. Instead, it's focusing employers to instead check the view improved digital status or the certificate of application. But this approach really focuses the obligation and risk still to the employer to do the right checks and to be able to understand what they're doing when someone comes up to them and says, I want a new job, and that only just made a late application to the EU settlement scheme. The UK Home Office guidance on public funds has been changed to confirm that those who submit a late application to the scheme will be able to access benefits and services if they are eligible for those benefits and services from the point that their application is validated and their identity has been verified. And that guidance confirms that there will be some legislative changes required to be able to ensure that the laws are compliant on accessing public funds. But the Home Office and the UK government said that they don't feel many of the other changes require legislative changes. What does that mean in practice? Well, the employer's guidance will tell employers you can offer a new job to someone who's made a late application to the scheme. However, the underlying legislation behind that still tells the employee that they're potentially committing a criminal offence because they're working without permission to be in the UK. They don't have an up-to-date immigration status. So what the Home Office are doing, in essence, they're saying that, well, the law is that, but we'll disregard the law and we promise not to charge you with any criminal offending as long as the employer and you follow this guidance policy document that's published on the website. Now, how much we can rely on that, I don't know. I mean, as a lawyer myself, I feel a sense of unease relying on promises rather than legislative changes which are set in stone. Apart from that, the Home Office are saying, well, we don't really need to make legislative changes because the withdrawal agreement has direct effect. So you can just rely on the terms of the withdrawal agreement because they take precedent over UK immigration law. I mean, apart from the fact that there's been disdain by some UK governments about EU law having direct effect, it's kind of ironic that they're now relying on that points to be able to avoid making legislative changes. But it's problematic for other reasons because the withdrawal agreement is about people who are protected under the withdrawal agreements, but the EU settlement scheme protects a whole bunch of other people who are not protected under the withdrawal agreements. So how much they can rely on the withdrawal agreements if they're not protected by it is another matter. And there are also other problems with this approach because the Home Office is saying you can access these rights and entitlements once you've made a valid application and that application has been validated by us. Well, we know that there's a delay between submission and between the Home Office validating an application and saying, here's your certificate of application and here's your view improved status. And that gap can be several weeks, if not months, as it seems to be at this point in time. So that still has there's still going to be a window of weeks and months before late applicants can access these new rights and entitlements. And I'm not sure that that's withdrawal agreement compliant. The withdrawal agreement says that a certificate of application needs to be issued immediately. Weeks and months are not immediate. That's late applicants and accessing rights and entitlements. I want to touch on a couple of other areas if I still have time. There are lots of problems with entering the UK and crossing the border right now. We've heard some of that in the previous speakers. Travelling into the UK is becoming a bit of a problem. And this is because airlines have a responsibility to check the resident status of inbound passengers, or they face the cost of returning people back home. But the Home Office have said that there's no legal obligation for airlines to check an immigration status, and they're not mandating airlines to use the View and Prove online service to check EU citizens entering the UK and whether they have an immigration status or not. And the Home Office have said that they hope airlines will instead use alternative checks, such as a boarding card or a checklist or a form that passengers need to fill in. The Home Office also says that they're working with partners to start educating airlines about this new approach from September onwards. The problem with all of these approaches is that airlines will have a strong motivation to check an immigration status because they are liable to return the citizen back home at their cost if they have got it wrong. And also if they use alternative methods of checking an immigration status, such as a form that the passenger needs to fill in, well, that puts the burden and liability on the passenger, and the passenger needs to understand what their immigration status is and what their rights and entitlements are. Sometimes people are going to get that wrong, and we don't really know what the consequences are, if any, if they get that information wrong. Certainly from the airline, there'll be a financial cost. From the individual themselves, there may be costs in future entry to the UK because they've disclosed misinformation on an immigration document. So if airlines do want to undergo these checks themselves, they can't view the screen on a device to see the rights and entitlements. They have to use the view and share code, which then presents problems by pushing the administration of this on the borders and adding to delays and confusion and risks of people not getting an entry. And these are some of the reasons why there's been problems at the border and why there's been talk of people being detained. This is immigration officers on the border putting people to one side until they can check all of this stuff because the airlines haven't done it properly themselves. Linked to travel, there's going to be a change from the 1st of October, because anyone who is doesn't have a set of status or pre-set of status, or is also a group protected under withdrawal agreements, will no longer from the 1st of October be able to use their national ID card as a travel document. They will have to use their passports to travel into the UK. And those who have applied to the EU settlement scheme, those who have a pending application to the EU settlement scheme, those who have pre-settled or settled status, a person who has a S2 healthcare visitor card, Swiss nationals who hold a visa as a service provider from Switzerland, family members under the EU settlement scheme, frontier workers can all use their national ID card until at least the 31st of December 2025, and beyond then if the national ID card meets the rules on biometric documents. That's not an easy list to understand, but it does mean there are going to be changes for people entering and exiting the border if they're not covered under these groups. And not holding the incorrect document on arrival could mean refused entry, could mean impacts on future applications to enter the UK, and so on. So we're going to need to make sure that anyone who's non-EUSS, non-withdrawal agreement cohorts, so to speak, will need to have their passport in order to enter and exit the UK. Of course, there are practical problems to this because trying to get a passport and national ID card right now is not a swift process. Two more points, and then I'm going to stop. Some reports of universities not accepting certificate of applications or the view and prove status for students to qualify for home fees. And some universities, worryingly, are asking students to apply for a student visa instead if they want to get a home fee. So there's a lot of confusion with some universities giving wrong immigration advice and potentially quite destructive immigration advice. And also not understanding that a certificate of application or a view and proof status will be enough to trigger home fees. This is a worrying development, and we are seeing a lot of reports on that, and it may be that we're just seeing quite a lot of them because it's admission season at the moment. So what we intend to do through some of our work is to try and talk to university groups to try and understand what's going on and to try and ensure that they understand what the rights are to accessing home fees. And accessing home fees will be available for those late applicants who will also be able to get to the verification stage and will have their certificate of application and be able to access a view and prove status. The last thing I'm going to touch on is reapplications and those who have received refusals. I want to touch on this briefly because we've had worrying reports from the Settlement Resolution Centre and also some advice organisations who have talked to people who have been refused pre-settled or settled status and who are worrying about going through the administrative review and appeal process because those processes take a long time to get through. And some of the advice that's been given appears to be wrong. And some of the advice given to individuals is that they should reapply to the scheme rather than do an administrative review or an appeal. Now, there are several problems with that. I mean, first of all, you should avail yourself with any of the remedies that you have available to you to be able to challenge a refusal. So use administrative review or use the appeal process and speak to a lawyer to decide what's the right avenue for challenge for your particular case. The also worrying thing about asking people to reapply instead of using administrative review or appeal processes is that, first of all, there's going to be a period of presence in the UK without any lawful status if you ignore the last application and try and apply again via the late application process. This will not necessarily have an impact on the EU settlement scheme part of the process, but it may have an impact on someone who wants to apply to become British later on. Second of all, I'm not quite sure if the Home Office will accept the reason for this late second application, because the reason would be I didn't want to use the admin review or the appeal process because it would have taken too long. And so I don't know if the Home Office would accept that as a justifiable reason for a late application. So there may be problems even with resubmitting a late application and getting that validity. And also, and this will be based on each individual case. Some cases may only be solved through administrative review or appeal because there were the particular refusal grounds. And a late application, while it might be able to get someone back into accessing rights and entitlements, the outcome is nevertheless going to be the same because it's the kind of refusal that can only be dealt with by an immigration judge. So again, like when it reaches refusal stage, it becomes quite complex. And I wouldn't rush to advise someone to make a second application and ignore the admin review process. I would encourage someone to try and access suitable legal advice if they can, and also try and discuss the issues that they have with them. I mean, that's the last point I really wanted to touch on now. And you can see from these points that the EU settlement scheme, while it's pushed millions through the process, it's not a done, it's not a finished scheme. There continues to be problems with people who hold to the status, and there will be continuing to be problems for people ongoing in the future. And this is why all of the work by all of the people attending this conference today and speaking today is vitally important, which is why I want to thank everyone for all of the hard work that they continue to do, because it's extremely valuable, and you're helping a huge amount of people in the small things that you do. So thank you very much.
Thank you so much, Chris, and thank you so much for joining us today and telling us about how things are going with the EU settlement scheme. I think we're all still surprised that over 6 million applications have been received, and I can tell you, yes, it's successful, but that success of pushing people through the scheme and getting so many applications submitted, that is down to the helpers, to the support organizations, whether that's the 3 million or settled or in limbo, or Citizens Advice up and down the country, or Citizens Rights Project in Scotland. They work extremely hard, and the Home Office's poster campaign, which you can see right here by itself, was never going to achieve that, but it's really down to the grant-funded organizations doing an exceptionally good job. And many of them are led by volunteers and really driven by passion. I just really felt the need to add that. I wonder why. Slightly personal involvement there. So thank you so much, Chris. I'm going to stop the recording